Joining me now is former Manhattan District Attorney Cyrus Vance. He's now a partner at the law firm Baker McKenzie. Thank you for joining me here this morning. So I wanted to start with, there has been a lot of reporting about your tenure as the Manhattan District Attorney. It is conflicting and is being used to attack the merits of the case. So I want to clear up any confusion here if we can. One narrative is that you declined to move forward with an indictment in the hush money case, and Bragg revived the case. There's a conflicting narrative that you pumped the brakes until. So when you left office in 2021, how close were you to an indictment on the hush money case?
Good morning, Jen. Thank you for having me on the show. There are going to be limitations about what I feel I can communicate to you. Some of the response would be internal deliberations of the office that I feel that are, to be kept confidential. But I think it's safe to say, looking at the front end of the story, the Southern District of New York, at the same time as ourselves, the Manhattan District Attorney, so-called hush money payment. And then we learned from the Southern District of New York that they asked us to stand down. And by stand down, I mean they were communicating that this ongoing investigation, and they wished that we put our investigation. And obviously that was a discreet call by me whether or not to do that, but I felt it was entirely appropriate. Obviously, the Southern District of New York is it's an excellent organization with great prosecutors, and I felt that was appropriate for me to press the bid. I was surprised after Michael Cohen pleaded guilty that the investigation from the Southern District on that issue did not go forward. By that time, we had moved on to others. Those other matters are really a matter of very much a public record, which I can discuss. Lawsuit against myself and this in federal court, attaching a grand jury subpoena that we had issued to the Trump organization, seeking to block our efforts to gather his tax returns and other financial information. That led us on about a 2-year saga. Were reviewed by 2 district judges at separate times, 2 courts of appeals panels at several times, and twice to the Supreme Court. And ultimately, Justice Roberts, in the majority opinion, said some, I think, very important things, which is that reaffirmed the principle that even particularly for information that predated their presidency, that there was no political motive evidence in anything that we were doing, and ordered the tax returns to be handed over. Within 4 months, the office had presented to a New York County grand jury for numerous counts of tax violations, and the CFO of the organization as well. And then subsequently, about a year later, the case went to trial, and the organization was convicted of perhaps all storyline. In terms of the second part of your question, when I left office, what had happened during the time I was in office in this period was there was a difficult time in New York City to get work done. Number one, we've been asked to COVID hit in the spring of 2000, which greatly impacted our ability to gather witness evidence, to convene grand juries, because the courthouse grand juries were not functioning. And certainly wasn't until the spring of 21 when the court issued its order to move expeditiously. What happened is that because of the delays, all the work that I had hoped to do, I was not able to do. And when I left, I understood that it was going to be Alvin Bragg's decision as to whether to conduct the investigation that we were running or to start his own. And so,
specifically because it's being used to attack the strength of Bragg's case. And there has been reports, including by people who worked in the office, that you did authorize an indictment moving forward. So I guess the question, just to go back to it again, is did you authorize one before you left
Well, there's been a lot of reporting on that, and I'm going to answer it this way. If I did, it was on the understanding I knew that we had not fit work, and it would ultimately be District Attorney Bragg's decision whether to move forward with the investigation. And of an understanding of the process, I just think this is important for people to know out there. Were you presented with a prosecution memo, which would have been one of the final steps, if not the final in the process before an indictment? About internal communications, I really don't feel I can answer without breaching confidences. No disrespect, but that's kind of the rules of the road. Understood. When Bragg started, he suggested that the case wasn't ready, about the strength of the evidence that you handed off, because you did a lot of work before you left office, even if there wasn't an indictment issued. Look, I brought Mark Palmer into the office in 2021. I think very highly of him, as you know, as what Mr. Bragg has said. Ultimately, Mr. Bragg decided that information, the case that Mark presenting him after I left in January 2022 was, and that's his prerogative as the district attorney, just as it was my prerogative when I was district attorney, to pursue evidence in furtherance of an indictment that I felt could be justified. Now, one of the people you engaged with during your time was, of course, Michael Cohen, who you'd be comfortable at this point putting him in front of a trial jury. Well, the issue is not whether I'd be comfortable. The issue is whether the office today is comfortable, and it appears that they absolutely are. As I've said, I think attacked, cross-examined on his prior statements, his prior guilty plea. But that doesn't mean Mr. Cohen is not a witness who can't be believed. I've tried many cases with witnesses with lengthy criminal records who support what he says. Then juries, as they will be instructed by the court, are absolutely free to believe a witness, whether he or she has a criminal record or any other, any problem. So I think I don't know the evidence that Mr. Bragg has, but Mr. Cohen appears will be a key witness, but that doesn't mean necessarily that Mr. Cohen won't be believed by a jury at whatever point this goes to trial. Now, former President Trump has been relentlessly attacking both the Manhattan DA overseeing this case. Based on what we've seen so far, could you make the argument that what Trump has said publicly amounts to a crime from what you've seen to date, and would that be chargeable? Well, I discussed this earlier today with your colleague, Chet. I think the president's comments and his tweets and writings and pictures are not just inappropriate; they're wrong. They're wrong on many levels. So I think from just a personal perspective, I think it's terrible judgment, obstructing governmental administration or law. Now, it's a misdemeanor. But the essential elements are to threaten, intimidate someone in order to public official in order to affect their decision making. Now, you and the tweets and the pictures and the comment and listen to the comments and decide. But what my comment was earlier today is if I were Mr. Trump's lawyer, I would tell him to knock it off because it's not going to help him with the judge. And if it is charged, it's not going to help him with the jury. Trump is planning to hold a press conference, a public statement on Tuesday as well. So just so people understand what the options are here, do you think it would be appropriate for the judge to restrict what Trump is saying in order to reduce the potential for violence, like a gag order or other options? First time that a gag order if it was issued by Judge Mershon, would have been imposed in a case. I think the challenge in a case like this is that America is sort of 50-50 on the issue of this prosecution. Mr. Trump could be told to talk, but it's going to be very hard to stop others talking for him. So I'm not sure, quite honestly, how effective a gag order would be, but I'd say that Judge Mershon would be well within his right to the degree possible, orderly and safe trial.
Now, I know none of us have seen what's in the sealed indictment, but for falsification of business records to be a felony, it needs to be in furtherance or to cover up a crime. During your time as the Manhattan District Attorney moving the case forward?
Well, I think that during our investigation, and I think I've commented on in terms of what's been reported in the press about DA's theory, that a charge in the Manhattan DA's office, in crime in particular, I don't believe we ever applied that to an election, federal election law, in order to elevate the misdemeanor business record to a felony. I think we did apply it in other in business record to a felony or federal statutes, but to my knowledge, I do not think we did that for a federal election offense. But that only means that it needs to be decided by the court de novo, and that's of bringing a charge where the law is perhaps unsettled.
Aside from the hush money case, you spent a lot of time and made a lot of progress focused on the Trump Organization finances, Trump's own finances. When you left office, did you feel there was a viable financial fraud case to be made in terms of people's expectations, a indictment from Bragg on that case?
Well, let's. By the way, on that point, I'm not sure what District Attorney Bragg has done since I left office. Whatever indictment he brings out Tuesday does not mean that that's the end of the investigation. Superseding indictments in the state court are as frequent as they are in federal courts. So what I'm saying, Jen, is that if District Attorney Bragg found an indictment that's focused on hush money and the like, that doesn't preclude him from continuing investigations into other potential crimes, and that's consistent with, I think, criminal practice and in almost everything that I know of.
So we don't know yet, but for people's expectation, be the last we hear from the DA's office on Trump and a potential indictment. At the time you had handed it off, and had you approved an indictment of Trump on his finances before you left office?
Well, again, Jen, I've said that I'm not going to discussions with the lawyers in my but as I've said, if I had I made that decision, it would have been Mr. Bragg's decision to review, because we were unable to complete our work given the constraints that I identified earlier: COVID, Supreme Court.
Obviously, you can't predict what a judge would do or whether there will be a conviction. I know you will not do either of those things, but is it conceivable that Donald Trump could serve time in prison for this indictment?
Conceivable, yes, but the likely outcome, simply because it's the lowest level felony. It has a maximum prison sentence of 4 years and a minimum prison sentence of no time, of literally just probation and typically without any criminal record would not be sentenced typically to incarceration if they were convicted of an E-level felony. Obviously, as I said, dynamics could change. If there were conduct during the pendency of the case amounted to additional criminal misconduct as it pertained to the security of the court or the district attorney or anyone else, that's, I think, as I've said, that can turn a otherwise case which significant jury impact, it can turn that into a case the jury's becomes a more serious case and for the jurors immediately, because they understand they're in the courthouse every day, know the importance of security, and so that could change the game.